The first thing I want to say today is there are a lot of stalls over here, and I'm not here to sell insurance. So I'm not an insurance salesman. Please do not misunderstand whatever I mention. The question is, Dr. Gitendra raised a very important point that when we leave our operation theaters or when we come to conferences and miss out on the sightseeing and the shopping and the trade, are we missing out on something, or is it valuable, or is it an asset to listen to topics such as these? Let us see and find out. Over the past 24, 25 years, I've been working in the field of medical negligence. I've heard these answers given by doctors. कि डॉक्टर नागपाल मैं तो 20 साल से प्रैक्टिस में हूँ, एथिकली काम करो, रीजनेबल चार्ज करो, कुछ नहीं होता. This was a professor of ophthalmology in one of the medical colleges in Punjab. 3 years later, he was sitting across my table and I asked him, Sir, क्या हो गया? He gave me a notice, Neeraj, ये notice आया है. I literally wanted to ask him, Sir, क्या हुआ वो ethically काम करने के बारे में और private practitioner के बारे में? The point I'm trying to raise is nobody is safe. Anybody who has not been sued under Consumer Protection Act is either not working or then he has just started working. Because anybody who's working enough or sufficiently in this country today will have a case filed under Consumer Protection Act during his professional career, and this number is going to keep on exponentially rising because we refuse to wake up when bills like Consumer Protection Bill 2018 are brought. Other doctors tell me कि मैं तो PGI में काम करता हूँ, SMS जयपुर में काम करता हूँ, मुझे indemnity insurance की क्या ज़रूरत है? Well, ज़रूरत है because government hospitals, civil hospitals, ESI hospitals, even where patient's payment is made through the EPF or any insurance scheme or the Army ECHS, all these cases are covered under Consumer Protection Act. We have innumerable cases filed against resident doctors of government medical institutions. Anybody has a doubt on this, they can contact me, I can give them a list. One gentleman once told me, Neeraj, मैं तो हर साल 50,000 लाख रुपए अलग रख देता हूँ, 2-3 साल बाद कोई केस होता है, 2-3 लाख रुपए लगते हैं, बात खत्म हो जाती है. Well, the problem is, one, there is no limit on compensation which can be asked for. Do you know what was the compensation asked for by Kunal Saha, which was finally, and in 1997, he was asking for 77 or 78 crores, which he later raised to 97 crores, plus interest. With interest, the amount he was asking for finally was 200 crores. So we should thank the Supreme Court that they did not award the amount he was actually asking for. We have more cases where 150 crores has been asked for recently in Delhi. So the point is, there is no limit on the compensation which can be asked for. Interest on compensation may actually be more than the compensation which is awarded. And your insurer, I mean, when you present insurance in court, the court sees कि हाँ जी डॉक्टर साहब की 20 लाख की इंश्योरेंस है. Then they decide कि okay ठीक है पेशेंट ने 50 लाख मांगा है, 20 लाख की तो इंश्योरेंस है, 20 लाख का compensation दे दो. What you don't realize is the court is also awarding a interest, and the indemnity insurer is covering you for the 20 lakhs. It is not going to cover you if the interest component is going to exceed the amount of insurance you have taken. So this interest creates a lot of problem. And more importantly, the actual award may be more than what the compensation has been asked for. So whatever gold you have collected, it can go in one single compensation. Compensation awarded can be more than originally claimed. This is the Supreme Court judgment which has mentioned this. And in this particular case, 3,200 was the only dispute. The case started by the patient claiming 3,200 rupees, which he spent in private hospital when he said that the matter should have been held in the civil hospital. The doctors kept contesting this case, went to National Commission. The National Commission awarded 5 lakhs instead of the 3,200. And interest charged on compensation, look at the interest given over here, 18%. 18% interest if Kunal Saha's case had been awarded from 97 till 2013. Can you imagine the amount of compensation it would have become? More than 18-20 crores. And it is on the judge's whim and fancy, whether वो बीवी से लड़के आया, नहीं लड़के आया, वहाँ 6% बोलना है या 8% बोलना है या 9% बोलना है या 12 या 18, there is no hard and fast fixed rule. The interest is awarded as per the discretion of the courts. Interest on compensation actually can be more than the compensation which has been awarded. And there is another very major issue, that under Consumer Protection Act, everything has happened. The court decided there is no negligence, and we have 6 or 7 cases where, despite agreeing that there is no negligence committed by the doctor, the court is requesting the lawyer, who's also there from the insurance company side, कि डॉक्टर साहब तो इंश्योर्ड हैं, थोड़े से पैसे इनको हम दे दें. This compassionate compensation is something I feel very strongly about. In this particular case, what happened, the lower court awarded a lakh or 2.5 lakhs or something, and when he appealed, the complainant said in the appeal, I need 1 lakh rupee, I have to get my daughter married. The court said, okay, fine, release 1 lakh rupee to him. The money was released. Later, the court gave a decision, there is no negligence. Now, 1 lakh rupees has been taken by the person. And the doctor proved in court that the daughter was already married 10 years ago. So, this was a false plea he had taken in court. Instead of prosecuting him for perjury, the court requests the doctor कि उसका बेटा मर गया है, it is an unfortunate incident, so we request you not to recover the amount from him. Quantum of compensation, Dr. Saab has already alluded. V. Chandrasekhar, then we had this Harjot Ahluwalia versus Spring Meadows Hospital, Prashant Dhanaka and Kunal Saha. What you don't know is, even free eye camps which are being held, there is a recent judgment of around 9 point some crores which has been awarded against a Tamil Nadu or a Kerala hospital. My article on that may be published soon in Indian Journal of Ophthalmology. But even for free eye camps, this kind of situation exists. This is the case where 150 crores compensation was asked for. And when doctors tell me that they are government doctors and don't need indemnity insurance, this is a municipal hospital in Mumbai, and the guy was a laborer, and he came in seizures. And when they gave an IV phenytoin, there was some extravasation, thrombophlebitis, compartment syndrome, and amputation finally had to be done because of gangrene. 21 or 22 lakhs was awarded in this case when no charges were made at all. V. Krishna Kumar judgment, also of Madras High Court, was premature delivery conducted in a government hospital. Child is perfectly fine. Only thing is they did not screen for retinopathy or prematurity. And on this ground, finally a compensation of 1.73 crores or something was awarded with interest, which came to around 2.63 crores against a government hospital and government doctors. So when doctors tell me that I'm working in a government setup and I don't need indemnity insurance, I want them to be aware because of these cases. Free treatment in government hospital covered. Safdarjung Hospital, one example. This is an ECHS case, ESI, all these are covered. PGI, Government Multi-Speciality Hospital, Chandigarh, totally free hospital. And against AIMS, I can give any number of cases. So doctors working in government institutions should not be under the misperception that they are not covered under Consumer Protection Act and they do need indemnity insurance. And if my suggestion is taken, they should encourage the resident doctors. My daughter, as an intern, we gave her indemnity insurance. My son, as an intern, we gave him indemnity insurance. But unfortunately, in her entire residency of MS Ophthalmology, she was the only resident of the medical college who had an indemnity insurance. I could not convince the others to take it. This is the case of V. Krishna Kumar. I had already alluded to this. This figure of 365 is wrongly shown here. Actually, the figure was 2 crores 60 some lakhs. the interest was calculated on something different. This is a case where totally army hospital. This was actually, doctor was a friend of mine. I'm an endoscopist. And this was a post-CA radiotherapy dysphagia. The doctor was doing an endoscopy and he could not proceed. Technical difficulty, he abandoned the procedure. And next day the patient comes with throat pain. ENT person saw, advised some antibiotics, but also advised some steroids. And person was okay for a day or so, but 3-4 days down the line, she was admitted in Batra hospital, remained admitted for nearly 90 days. And with empyema and perforation and a lot of things. And here in this case, 12 lakhs was awarded, but this was not through a consumer court. This was under Article 226, which is violation of fundamental rights. And the case was filed in High Court. And this is what I'm trying to say, that even government hospitals, but if the doctors were having indemnity insurance, this amount would not have been borne by them. Now, the crux of the talk is, however, is indemnity insurer your friend or foe? I have so far sold you the idea of taking an indemnity insurance. I'm not saying take it through me, or take it through Dr. Lalit Kapoor for Association of Medical Consultants. You can take from whomever you want. But the fact remains, so far I have been presenting you the picture that you require indemnity insurance, irrespective of whether you are in a government sector, private sector, or a semi-formal sector. Now you have indemnity insurance, but the question is, are indemnity insurers your friends or foes? When I see the insurance of people, either they are uninsured, underinsured, incompletely insured, fraudulently insured, unknowingly insured, what is the relevance of practicing anesthesia in a city for the past 15 years and coming to me with a case which has been filed against you, and when I ask you to, the first thing you have to do is inform your indemnity insurer, the doctor very sheepishly tells me, Doctor Sahab, indemnity insurance to maine li nahi. I mean, then it is stupidity beyond the definition of stupidity. Today, if you are practicing medicine, it is criminal if you are not having indemnity insurance. What are the mistakes you do to make? One is, when the guy comes to sell you the indemnity insurance, he tells you you require 2 types of indemnity insurance. One is a personal professional indemnity insurance. Second is an error and omission policy for the clinical establishment you are working in. You say कि यार इतना कहाँ हमारे होता नहीं है, कभी एक policy दे दो. So when you take one policy, what are the problems which occur? Look at this case. Insurance was taken by Dr. Amarbeer Singh, whereas the patient was not treated by Amarbeer Singh in the hospital. Other doctors involved in the case were not insured, neither was the hospital insured. So any compensation awarded, the insurance company says we are not liable. And the court upholds it. In this case, the radiologist was insured. They went ahead to do an MRI under anesthesia, and the patient died because of anesthesia. Now, the case was not filed against the radiologist. The radiologist had nothing to do with it. The case was filed against the anesthetist as well as the MRI center. And the MRI center by name was not insured in an error and omission policy. The doctor was insured, but the doctor was not named in the case. So the insurance company denies any liability. It may be a proprietary concern of the person. For financial reasons, you can argue it is the same entity, but all these arguments for the indemnity insurer, you are giving them a loophole when for a sake of 2, 3,000, 5,000, 10,000, saving that amount, because indemnity insurance in India is very, very cheap. And when you take it through a group like Medical Legal Action Group, which I am running, or IMA is providing its own indemnity insurance, AMC is providing very good quality indemnity insurance, we get you discounts over and above what the rack rates are. If you are a gynecologist and if you are insured in USA, you can expect indemnity where the premium you are paying is upwards of $100,000 every year. People stop practicing because they cannot afford the indemnity insurance. Here we offer you indemnity insurance. In 8,000 rupees, you are having indemnity insurance of 1 CR. In fact, in 4,000 and 5,000 rupees, second year onwards, MLAG offers you indemnity insurance for 1 CR. And still we remain miserly. Insurance again not taken for the hospital, and the case in this case is not against the hospital. So the insurance company says we are not going to pay. The doctor may be insured. The doctor is not named in the policy. The doctor is not named in the case. So insurance should be in the name of hospital as well as individual doctors. Because this clock seems to be running very fast, I'm not going to dwell on each and every case, but the fact remains, take insurance for yourself as well as for your establishment. Then, if you simply pay 7.5% premium extra, you can cover your unqualified attendants. There was a case of fracture femur, undisplaced. They applied a cast. Before discharge, they wanted to take an X-ray. The patient was sent on a trolley down. While shifting the patient from the X-ray trolley to the X-ray table, they dropped the patient. Now what happens? When the patient dropped, the fracture got displaced. Now the case is filed because there is negligence of the helper who has shifted the patient. And the helper is an unqualified attendant. In case you do not have unqualified attendant cover, you are giving a loophole to the insurance company to deny liability. Why do that? Again, 7.5% with 70% discount on the rack rates doesn't even amount to a 200 or 300 rupees when we are talking of insurances of 50 lakhs or 1 crore. In this case, the doctor had a policy for the unqualified attendant and he was saved. But most important is, when the agent comes to me, I tell him, nahi yaar, 13,000 bahut zyada rate hai. So he goes out, he does some calculations, he comes back. डॉक्टर साहब मैंने आपके लिए रेट ना 8,500 कर दिया है, पर प्लीज किसी को बताना मत कि मैंने ये 8,500 किया है, अदरवाइज मेरे लिए प्रॉब्लम हो जाएगी. यू फील वेरी हैप्पी, मेरे लिए रेट कम कर दिया. What has he done? He has changed the quality of your insurance. From 1:1, he has made it 1:4. What is 1:1, 1:4? Any one accident, any 1 year. If you have a policy of 10 lakhs and that policy is 1:4, then under those circumstances, if a case is filed against you and a compensation of 10 lakhs is awarded, the insurance company in one case is only going to pay 2.5 lakhs. Though in your mind, you were insured for 10 lakhs. So whenever you take a policy, please take 1:1. Again, same thing happened here. 4.5 lakhs compensation was awarded, but it was in ratios, so some amount had to be paid by the doctor concerned. Now, this was a government hospital, civil hospital. The doctor had an insurance of 3 lakhs, but it was in 1:2. So the court saw that he has a 3 lakh insurance. It awarded 3 lakhs, but he had to pay 1.5 lakhs from his own pocket. And the interest component in this ratio sometimes creates a problem. Here also, the doctors had an insurance of 20 lakhs. This was a nursing home in Chandigarh. But it was in 1:4. So the insurance company says, we will pay only 25%. Look at the insurance rate, how it changes. How he makes 13,000 to 8,000. Look at this. In the category for let us say, third category for surgeons, 1:1 policy, which costs 2,360 rupees, costs 1,416 rupees if you take 1:4. So the policy is saying 10 lakhs, but you are getting a 1:4 policy. You are not realizing. This is simply being miserly. So please do not do this. And when you compare the premium rate for 1:1 policy with unqualified attendant cover of 50 lakhs between regular insurer rates and what any group, whether IMA, AMC, there are many others, Dr. Gitender's company also provides indemnity insurance. Basically, any group of doctors can get together and negotiate with an insurance company to get benefits, and that is the best way to take rather than directly taking from the indemnity insurer companies. Then comes the question, should you take one policy or many policies? If you take 1 crore policy and you go and give it to the judge, कि सर हमने नेशनल इंश्योरेंस को पार्टी बनाना है केस में, ये हमारी पॉलिसी है. कोर्ट सेज कि अच्छा 1 करोड़ की पॉलिसी है, डॉक्टर साहब तो बहुत रईस हैं. So the amount he awards is 50 lakhs, 60 lakhs, which he is being generous because you are supposedly covered for 1 CR. So when you are to take a policy of 1 CR, my suggestion is from the same company, take 3 policies, one of 20 lakhs, one of 30 lakhs, one of 50 lakhs. Why? Give the policy of 20 lakhs in court. It is from national insurance. We have all 3 policies from the same insurer. So if the court awards more than 20 lakhs, let us say the court awards 25 lakhs, all you have to do is, sir, by mistake, this 30 lakh policy was missed out. Here is the other policy. The insurance company cannot deny liability because the insurance company got an opportunity to defend itself. But if you had taken these 2 policies from 2 different vendors, then the other insurer will deny liability. We did not get an opportunity to defend ourselves in this case. Hence, we are not liable. So take multiple policies, but take from the same vendor. I know Dr. Lalit may have different views from what I am saying, but this is what my suggestion is. The question of how much should I be insured for, anybody practicing medicine in India today, even as a retired person who may someday have to treat his maid servant free of cost, is 50 lakhs. 50 lakhs is the minimum policy, and any surgical procedure is being done. Any endoscopist like me, who's basically considered physicians, we should be taking policies of surgeons, not taking policy of physicians. And when you take an indemnity insurance, please spend 5 minutes and fill the indemnity insurer proposal form yourself. हम लोग क्या करते हैं, साइन ये यार दे, मैं साइन करूं तो अपने आप भर ले. रॉन्ग. बंदे ने हॉस्पिटल का नाम गलत डाल दिया. राम किंकर हॉस्पिटल, श्री राम किंकर मेडिकल इंस्टीट्यूट. ये नाम के चेंज से इंश्योरेंस कंपनी गॉट अ अपॉर्चुनिटी टू डिनाई लायबिलिटी. Eye surgeon goes to multiple places to operate, endoscopist goes to multiple places to operate. Write down the name of places which all you go to operate, and write down at the end of it, and other hospitals as and when called to go there. Most policies nowadays, which are negotiated through doctor groups, says that coverage is for all over India. But we have so many cases where, because the hospital name has not been mentioned, where the policy has been taken from one place and the doctor has gone and operated in another place, there is a problem which has occurred. And please follow the terms and conditions of the policy. आपने पेशेंट ऑपरेट किया, पेशेंट की डेथ हुई, पेशेंट को कॉम्प्लिकेशन हुई, आपको एक फोन कॉल आया थ्रेट का कि डॉक्टर साहब हम आपको देख लेंगे. Please inform the indemnity insurer the day you get a telephonic threat also. Please inform the indemnity insurer if somebody barges into your office and says that you have negligently treated my patient. Do not wait to get a complaint, a notice from the consumer court. Do not wait to get a notice from the patient's lawyer. Any event which you think may result in a claim later, you are supposed to inform the indemnity insurer, and if you don't do that, they will deny liability. Like here, the doctor informed only after the case had been filed. And do not inform them without a receipt. So send a registered post letter, send an email, send a boy with a copy of the insurance, with a copy of the complaint, and take a receipt from them. Because verbally you will be assured, Doctor Sahab, koi problem nahi, hum dekh lenge. But like this verbal insurance in this particular case, nothing happened once the case was filed. They denied कि हमसे तो बात ही नहीं हुई. Insured shall give a written notice to company as soon as reasonably practical of any claim made against the insured or any specific event or circumstances that may give rise to a claim being made against the insured at a later date. So do not wait to get a notice. You cannot involve the company after the compensation has been awarded, obviously. The most important message is, as soon as possible in a case of a problem, inform the insurance company in writing. In this case, FIR was filed, everything happened, only the doctor waited for a notice to come from the consumer court, then informed the insurer. So, hala, in a criminal case, the insurance company has no role to play, but they will have to be intimated that later this case may result in a claim to be filed against me later. And do not depend on verbal assurances of insurers. Please remember, the policies in India are claim-based, not event-based. So, most insurers will threaten you कि अगर डॉक्टर साहब आप अपनी पॉलिसी हमसे चेंज करोगे, दूसरी कंपनी में जाओगे, पिछले साल अगर का कोई केस हमारे पे आएगा, can I be allowed 2 minutes, sir? अगर हमारे पे कोई केस आएगा, we will refuse to acknowledge. If you have intimated the insurance company of any event which happened during the policy coverage and up to 2 to 3 months after the policy expiry. अब किसी की 31 मार्च को एक्सपायर हुई है पॉलिसी और 31 मार्च को इंसिडेंट हुआ है, तो वो 31 मार्च से पहले कैसे इंटीमेट करे? So there has to be a reasonable time given after that. If you have informed and the case has been filed, let us say 10 years later, though limitation under Consumer Protection Act is 2 years, under law of limitation is 3 years, but there is something called discovery rule, which under Consumer Protection Act indefinitely extends this period, and we have cases which have been filed 11, 12 years after the actual cause of action. So if you have already intimated and have a receipt that you had intimated your insurance company, after that, even if you have changed your policy to another indemnity insurer, it does not matter. Refusal to pay compensation for documentation lacunae. When the company asks for medical records, please provide it to them. Many cases are there, but I think for the shortage of time, unfair trade practices are not covered. This was a MS surgery person who, MS orthopedics, who was doing lithotripsy in his nursing home. Take home message, get professional indemnity insurance, even if you're retired, if you have to someday treat your housemaid free of cost. Minimum professional indemnity of 1 CR for hospital nursing home, 50 lakhs for individuals who are non-surgeons. Take policy for a single event in 1:1. Do not go for 1:4 policy or 1:2 policy. If you have a mishap, take another policy if you feel your policy will be spent in that case. Send written information to insurers on receiving any notice via registered post. Copies of notices along with all relevant medical records can be submitted later. Inform company to engage a defense counsel. Be prepared for the company to disclaim responsibility on flimsy exclusion clauses. And insurers, remember, can reach an out-of-court settlement even without your concurrence. No insurance company liability if services have been rendered under the influence of alcohol or narcotics. In cases involving cosmetic plastic surgery, special interest groups like MLAG, we have negotiated with the insurers for providing cosmetic cover also, but then they charge 75% loading extra. AMC is providing cosmetic cover. I'm sure Dr. Gitinder's group also would be probably doing that. And cases of AIDS, we have made a representation to IRDA against this clause. I think this clause of patient being AIDS should be excluded is unfair, and when we are giving so many rights to our AIDS patients, it is uncalled for. Thank you so very much.
Thank you so much, sir.